This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
And without any further ado, I will go ahead and give a little bit of an introduction for some of our panelists here. Let me get my slides up and running here. So welcome to today's presentation, who you're going to call the Case Busters. Today with us, we have Judge Susan Lopez-Giss from the LA Superior Court. We have Commissioner Glenn Oleon from Contra Costa County in Northern California, Rich Roggia, based in the San Jose, Silicon Valley area, and Judge Charlotte Woolard, who was from San Francisco Superior. Without any further ado, I would be happy to turn it over to our first speaker, Judge Lopez-Giss.
Hello, everyone. Actually, I just retired from the Los Angeles Superior Court, and I want to welcome everyone today to look and get answers to why mediation and why using neutrals is a good idea. I was a prosecutor in the Los Angeles City Attorney's Office for 15 years, litigating, meaning trying cases, and then I was general counsel for the Los Angeles DWP. Contrary to what many people in the plaintiff's bar thought, DWP does not mean deep, wide pockets. It means Los Angeles Department of Water and Power. But what I learned after 30 years of trying cases was that the best thing to do was to settle. As I'm going to repeat again and again, nobody hits it out of the park when they go to trial. And it is never more true than in family law. So why would you go to mediation? Well, the easy answer is to settle the case. Of course you want to settle the case, but before you settle the case, you want an open-minded, candid conversation with the parties and a neutral so that the neutral can explain options and risk. And I'm going to discuss risk in a little while. Why do you want this conversation? You want it so the parties can make an informed, rational decision. Because as we all know, parties in family law are the most rational. Slide, please. As this slide indicates, that contrary to my sarcastic tongue-in-cheek comment, clients in family law are far from rational. They're angry, and they have an expectation that you are going to produce results. They're angry and emotional. I think COVID has exacerbated it because their financial security is at risk. Their former best friend is now their best enemy. They have uncertainty with respect to their children. And they have many, many people pulling on them, telling them what to do. Oftentimes, a petitioner will file for a divorce or a paternity action because they want a change in the other person. I call it family law poker. They think that what's going to happen when they file that paperwork, that the other person is finally going to get the message and change. And the respondent oftentimes never saw it coming. Doesn't matter how many times the petitioner will have said, do this or do that or change. Otherwise, it's going to be divorce or court. They don't believe it. And when the respondent gets served with papers at work, or in bed with a girlfriend or wherever it happens, holy DEFCON 5 results. And they march into your office expecting that you're not only going to show them the money, you're going to give it to them that day or soon thereafter. And what I often see, and I know that you see, is people who do not want to sit down and talk. They want you just to understand and fix it. Next slide. The worst part about family law is that the parties think that they can tell their story. They have no concept of admissible evidence. They don't understand that California is a no-fault state. So the 10 years of experiences with the other person, including how horrible the mother was, the father-in-law was, the family was, the job was, the secretary was, is never going to get introduced. And they want you to listen to it and they want you to present it. And the problem with that whole concept is that oftentimes you need somebody who's going to explain to them what the risks are, but more important, what actually will be introduced into court. Slide, please. As I mentioned a moment ago, nobody hits it out of the court in family law. What I often tell the parties is that when they go into court, it is the equivalent of going to Las Vegas and putting all of their money, all of their property, and their children on one number. Not a color, but a number. A color would give them a 50% chance of success. I say that anyone who's been to Vegas more than 2 times recognizes that the second time they went to Las Vegas, it didn't look like the first time. And the reason for that is that the owners of the casinos, the owners of the hotels, took all of the money that the people bet on one number, imploded the buildings, and built something else. People think that with your help, you are going to go into court, roll these dice, and come up a winner. And it just doesn't happen. And if you tell the parties this, you become lawyer number 1. And everyone else on this call or this Zoom becomes lawyer number 2, 3, and 4. And the issue of risk management is incredibly important in family law. I will ask the parties when they come to see me, the first thing, how much money have you spent so far on this case? It's astonishing. They don't know. They look at their lawyer, they look down, and I say, no, don't look at your lawyer. It's coming out of your pocket. They don't have a clue as to how much they've spent. And here's the next question. How much are you arguing over? A lot. Too much. But they don't know the specifics. And the final question, how far apart are you from the other person? They don't know that either. And what I have seen sitting on the bench in 15 years of family law is that people will go through more money than they will ever recover. And they will do it because they're angry and they don't understand the risk and they don't understand what they're going to be able to say. And they also don't understand the likelihood of the success. The cost of experts, the cost of discovery, the cost of consulting, and your cost, all with good intent and all according to the rules of practice and making sure that your malpractice insurance doesn't go off the chart, oftentimes results in people spending not only more money, but emotions and destroying the children and the family. And the whole concept of mediation is to be able to help you help them. Next slide. But more important, let me and my colleagues help you. Family law has a code, the family code, and the rules of court and the family code, regardless of what jurisdiction you are in Los Angeles, require case management. And with case management, the rules of court require meeting and conferring before you bring any motion to be heard in court. Meeting and conferring is not what I learned in civil. It is not writing a letter to the other side and telling them how many ways they can basically not basically take care of themselves. I don't want to be offensive, but you know what I mean. They're not nasty letters telling the other person how horrible they are. They are not nasty letters saying, you do what I want, or you give my client what they want, or else. Meeting and conferring requires discussing the issues you disagree about. When you come into mediation with me, or when you came into my court, I would ask for a joint statement of disputed facts. I don't care if it's one issue or if it's 100 issues. It is not, we don't agree about anything. What it is if it's support, what are the issues you disagree about? Income, if it's a timeshare issue, timeshare. If it is because you don't know the value of the property, indicate that so the parties understand what it is specifically they are disagreeing about. Telling a court you don't agree about anything is an obvious statement. We wouldn't be here, we wouldn't be talking if you agreed about everything. In doing that, that helps frame the issues. One of the things that I bemoaned when I became a family law judge is that there were no jury instructions. Because whether you're trying a criminal case or a civil case, you had instructions that explained under the law what you have to prove. In family law, there are no instructions. Your client is telling you what they want. But in the sense of framing the issue specifically as to what you're trying to prove, mediation can help you do that. Meeting and conferring and framing the issues you disagree about gives you a roadmap, gives you a game plan as to what your client is asking. It helps you frame the ask. And most important, it's all confidential. Under the evidence code, mediations are confidential. What is interesting is that mandatory settlement conferences held by the court are not confidential. So information that is given in a mandatory settlement conference conducted by a court can be utilized in a proceeding. But mediation gives you total confidentiality. That means the documents that you are presenting, that means the discussions you are having with the mediator, that means your client's heartfelt feelings can be discussed without risk of any of that information being used in either the trial or the hearing. I often say that it is an opportunity not only to get free discovery, but also for your client to be heard. In the previous slide, when they discuss the admissible evidence versus the story, the mediator will listen. A mediator will give your client the opportunity to explain all of the horrible, terrible life stories that they've experiences, domestic violence that was never charged, regardless of whatever it is, the girlfriend, the mother-in-law, the horrible partner, all of it can be discussed. And oftentimes that venting helps you because there is an independent person who will then say, this is tragic, it's horrible, my heart is broken for you, but you must understand that the California Evidence Code and Family Code will not allow you to present that. Once a person understands that, and once a person feels that a neutral, objective person has heard it, you can start talking about the real issues. And it gives you the opportunity to clarify and know a neutral's position as to your client's demand. Much time is spent in mediation allowing clients not only to vent, but to also listen to what the mediator thinks about your client's position and actually takes you off the hook. An independent assessment helps you have credibility with your client. Next slide. I use this slide, you want the truth, you can't handle the truth, because so many attorneys have told me that when they try to talk to their client, their client gets angry, their client will bring somebody else in to set you straight, to basically tell you that you don't understand. A mediator and a neutral will basically be able to explain the following. I tell the parties that come in front of me when I was on the bench and now that there is so much discretion in family law. The example I give is not the example we're using today, but pre-COVID, when we would all gather in huge ballrooms, 400 of us at a time, sitting around tables of 10, judges and attorneys alike, discussing an issue. What I will tell the parties, we could be discussing your issue. On the panel would be a judge, a forensic accountant, perhaps if it's a property issue, a child custody evaluator, if it's a child custody issue, as well as an attorney, discussing the issues and the facts and the law in that specific case. And then we would all pick up our clickers and vote. And what would be presented in about 3 or 4 minutes after the majority of the people voted, 25% might think that the petitioner is correct. 25% might think the respondent is correct. 30% might think neither of them are correct. And another percentage, the leftover percentage, might feel that this whole situation requires a new assessment or a new theory. The point of it is that there is so much discretion, there is no guarantees that anybody is going to rule the way you want, and for certain, not 100%. When people understand that and you explain issue by issue from the joint statement, you begin to get a rational basis for decisions. You can't make a person decide, nor would I want to make a person decide, but at least they have educated options. If the mediation succeeds and you have an agreement, you, counsel, are hero. You are the person who basically brought peace to oftentimes a years-long fight. You begin to make peace in the family. You give the children 2 parents who love them more than they hate each other. And if the mediation isn't successful, you've had a confidential opportunity to look at the answer book. Additionally, you have an assessment. You can have a mediator's recommendation. So you have some more tools in the toolbox to proceed with the next step of your client's case. Post-mediation options, oftentimes if you don't settle the first time, you offer the parties an opportunity to come back with the issues defined. And oftentimes, most of my colleagues will send a letter explaining what was discussed, what options remain open, so that you can go forward with your clients with a new strategy. It is the hope of everyone on this panel that we give you options and opportunities today to look at the various opportunities we present to help you be a successful assistant, attorney, and peacemaker with your clients. Thank you.
Thank you, Judge Lopez-Giss. Next up, we have Commissioner Oleon speaking about private judging options. Commissioner Oleon.
Thank you. I want to start by just saying amen to everything that Judge Lopez-Giss just said. I think that was a masterful presentation. I think she really just teed it up beautifully and pointed out to you the pitfalls, but especially the advantages of mediation. And I think the way that she described the process and the benefits of the process and what a mediator can do for you and your clients, I think was really well done. And I would just echo all of her remarks. When Katie introduced me a few minutes ago, she had one thing wrong. Although I live in Contra Costa County, I was actually on the Alameda County Superior Court bench as a commissioner for 10 years, and 8 of those were in a full-time family law assignment. And now it's really been my pleasure and my privilege to be with ADR Services for the last 9 years as a full-time neutral in the family law field. So that's kind of what brings me to where I am today. I want to start by dispelling a commonly held urban myth. There is no such thing as a private judge. Private judges do not exist. What do exist are temporary judges, and in particular, what exists are privately compensated temporary judges. So if you want to use the accurate term, that would be the term to use, not a private judge. And when I sign off on orders and judgments and such, generally speaking, I will sign them as temporary judge or judge pro tem, not as private judge, because that's a title that actually doesn't exist in the law. When someone is, but I'll use the term anyway because we all use it and it's very descriptive. When someone is acting as a private judge, they are in fact a judge of the superior court in which the case is pending. They become that, and I'll describe this in a little more detail in a moment. They become a temporary judge by virtue of the stipulation of the parties and the order of the superior court, generally signed off either by the presiding judge or the supervising judge. That varies somewhat from county to county. But once I am serving, or anyone is serving as a private judge, they are serving as a judge of the superior court, and they are bound by the same oath as the judges who get their paychecks from the court. And we are bound to apply the same rules of law to the same rules of evidence and the same rules of evidence as the judges of the courthouse do. So I think that's an important thing to often explain to your clients. You probably understand that, but the clients may not always know what a private judge or a temporary judge really is. So next slide. So the benefits of private judging are manifold. There are many, many, many of them. There's really only one significant disadvantage to private judging. I think you can all guess, that is, we cost money. Your clients are going to be paying a fee, perhaps splitting it 50-50, perhaps dividing it in some other agreed upon manner. But yes, we do get paid for our services. We are privately compensated temporary judges when we're acting. But that's really, in my opinion, the only downside. I think there are a tremendous number of upside elements. And I think that's why the business of private judging has frankly been booming, certainly during the years that I've been taking those assignments on. So what are the main advantages for you and for your clients in using a private judge? Well, first of all, you get the ability to choose your own judicial officer. When you have a case pending in the court tells you who your judge will be, and you have very little say in the matter. Yes, you can 170.6 the judge or judicial officer who's assigned to your case. But frankly, if you do that, you're going to get a second choice, and you may be no happier with the second choice than you were with the first. By agreeing with opposing counsel to select a private judge, you are able to choose a judge who has the experience in the subject matter, that hopefully gives you confidence that you're going to be getting at least a well-reasoned result, if not always the result that you're going to be hoping for. You get a judge with expertise in the subject matter field, and you get a judge who's a known commodity. Now, attorneys usually think that when they've been in front of a judge a few times, they've got that judge figured out. And they know pretty well that, oh, this is a generous judge about spousal support, or this is a judge who's a cheapskate about attorney fee orders, or various other things that you think you know about the judge. Frankly, my experience is you don't really know that about the judge. Judges are very honest, very serious about their jobs, and they're going to try their best in every case to apply the law to the facts, which means they're not always going to reach the same result from case to case, because every case is unique and different. But to the extent you think you know your judges, by using a private judge who you've used before or who has a reputation in the community. You're gonna get a known commodity, and you're gonna get someone who views the issues in your case in a way that you think is the right, or at least an acceptable way of viewing them. I know it's the experience almost uniformly throughout the Bay Area, not as true in some other parts of the state, but still in many parts of the state, that the judges and judicial officers that are assigned to family law are those with the least experience as judges, and frequently with little or no experience in family law. So being able to choose a judge who's been doing family law for some large number of years, I think, can be a tremendous benefit. It also means that you've got much less need to educate the judge. I see far fewer memorandum of points and authorities, for example, as a private judge than I ever did when I was on the public bench, because the lawyers appearing in front of me know that at least the basic rules are things that I'm familiar with, and that would be true for any experienced private judge. If your case is complicated or has unique issues or the law is changing, then of course, points and authorities are extremely helpful. But for most things that come before me, I don't need them, and that saves everybody time and money. Another advantage of private judging is scheduling efficiency and convenience. Generally, I will consult with the attorneys before we pick dates for any upcoming proceeding, and we can pick dates that work for all the participants. It's going to be a date that's available on your calendar, on opposing counsel's calendar, that your clients are going to be available, that if there's experts, that they're going to be available for a particular hearing, and of course that your private judge is going to be available. We do in private judging a lot of case management. I would say my experience is we tend to do much more case management in private judging cases than is true on the public bench, although as the judge said earlier, case management is certainly required in public court cases as well. It's not unusual for me to meet once a month with the attorneys on a case, even just for check-ins, to make sure that discovery is proceeding, that they have the information that they need, when they're going to be ready for the next step, whether that might be a hearing or a settlement conference or trial or whatever. Sometimes I'll meet with the attorneys more frequently than once a month, but there's a flexibility there that enables us to sort of stay on top of the case and stay on top of the calendars so that things don't fall between the cracks and cases go sideways on us for a substantial period of time. By being able to work together to pick our dates and to have regular case management, that really helps to minimize scheduling delays and continuances. You all have the experience where you've got a date that's been scheduled, and you think you're going to be ready to go, and lo and behold, it turns out somebody has a conflict, and then you end up waiting often weeks or months to get another date that's available on the court's calendar and such. That happens much less frequently in private judging cases. And when we do have to come up with a new date, we can basically either by email or by a conference call get together and pick a date in the very near future when we can have that hearing or that meeting that needed to be continued. Another thing that I think greatly promotes convenience and efficiency is that you can shift back and forth in private judging between trial and settlement modalities. It is very rare that in one of my private judging cases, we don't have at least one settlement conference or mediated settlement conference before we actually get to a trial. Sometimes we will have more than one of those, and sometimes we'll switch back and forth. I've had experiences, for example, where we will have a mediated settlement conference. We'll discover at that there is a threshold issue that just needs to be resolved before we can really move on. So maybe we'll have a bifurcated trial or a bifurcated hearing on that issue that's creating a logjam. And then once that's been decided, maybe it's date of separation or some other sort of standalone issue, then maybe we'll be in a position to go back to settlement discussions and move back and forth between those modalities to try and get to an efficient final result as quickly as reasonably possible. The other huge efficiency in the timing that's available to you in private judging cases is to avoid breaking up trials. If you told me right now your case is ready for a 5-day trial. Couldn't give you one next week. These days, I'm actually pretty busy. Couldn't give you one next month, but I could give you one certainly as soon as August, maybe even might even be able to squeeze something in July, but certainly in August and September and October. Well, if you were in the public court, I was just talking to some lawyers. I said, when's your next available in the public court? I was acting as a mediator, and they said the middle of 2023. That's almost never going to be the case with a private judge unless you need that long to be ready for your trial, in which case they may give you a date farther down the road. So you're going to get a date that's much sooner, almost always. And my experience way too often in the public court was you'd have a matter scheduled for a trial, and let's say it's a 3-day matter. It would be very rare the judge would give you 3 days in a row on their calendar and actually give you your trial for those 3 days. Instead, you might get a day in August and another day in October and another day in December. And sometimes those might have to be continued because something with higher priority comes along, or somebody's sick or unavailable or whatever. Or where I used to sit on the bench in Alameda County, we would often have half days, and your 3-day trial might end up being 6 half-day trials. That is going to very, very rarely happen with a private judge. You tell me you need 5 days, I'm going to give you 5 consecutive days, and I'm going to hold those days religiously on my calendar for you, and you will get your 5-day trial on those 5 days. Saves money, makes it obviously a much more appropriate resolution by not having to chop the case up like that. Private judging gives you a lot of flexibility. It gives you easy access to the judicial officer. I avoid having ex parte conversations or communications with either side, but with both sides present, if you want to communicate with me, we can do it, today or tomorrow. We can either communicate by email, or we can set up a telephone conference or a Zoom conference on very short notice, and we can talk about things really quickly and resolve things usually really quickly in a way that clearly you can't do with your judge at the public court. I've already said we can choose mutually convenient times and locations for our hearings and meetings and conferences and such. This is in some ways even almost more of an issue in post-COVID times than it was before. If we're going to meet for a trial, depending on where the parties live and such, first of all, there's of course the possibility of doing it by Zoom, doing it remotely. And I am open to that, even though I have a personal bias in favor of trials being in person for a lot of reasons. Credibility of witnesses and handling of exhibits are among the top ones. But nevertheless, I will conduct trials on Zoom if that's what's best. I just set a trial in a matter this morning before we came on. One of the parties lives in Ireland, so we were able to set the trial with them being able to appear in the case from Ireland. That would be much harder to do in the public court. And as far as location goes, ADR Services in both Northern and Southern California has a lot of wonderful offices with convenient and delightful conferencing capabilities, and great free lunches and great snacks and all that good stuff that if you've used ADR Services before. But if it's not convenient for you to meet in those locations, it may be that one of the attorneys has an appropriate conference room that's more convenient for the parties. I'm willing to consider that. I've had private trials in court reporters' suites, in county law library conference rooms, bar association conference rooms. So there's just a whole lot more flexibility. The one place we cannot have our hearings is in the public courthouse. There are such severe restrictions on that it may as well be considered an impossibility. But again, a lot of flexibility there to make it convenient for you, to make it convenient for your clients. Largely, we can operate by consensus to make our own rules. The flexibility is amazing. If, for example, if we want to make sure that a trial gets completed within 1 day by stipulation, I've often set up trials where we say, okay, you've got 4 hours to put on your side of the case. The other side has 4 hours to put on their side of the case. Everybody agrees to that, and that becomes our procedure. All kinds of procedures can be varied and made more convenient and more flexible by agreement in the private judging setting. Another flexibility that you've got there is the private judge can hear all the issues in the case, or can hear limited issues within the case. We'll talk, some of the other speakers will talk about referees and arbitrators, which is another way of solving this issue, but you can also appoint your private judge to hear only certain parts of the case. And in particular, many private judges are willing to be engaged just for the purpose of reviewing and, if appropriate, approving judgments, avoiding the long backlog that often exists at many courts in doing that. So again, a lot of flexibility there. There can be greater privacy in private judging cases. Usually the public is not present, though if you take a look at Rule of Court 2.834, the public does have the right to be present, and every once in a while in private judging, I will get a request from a non-party to actually be a member of the audience, and they do have to be accommodated in doing that, and there's rules for making that happen, but that's pretty rare. In general, the proceedings tend to be private, which the parties often prefer, especially in certain more sensitive or sophisticated kind of cases. Even though you're paying us, there is potentially cost savings. I would say potentially huge cost savings in many cases because of all the efficiencies that I just described. So I won't go back into those again, but they can definitely make the case a lot less expensive than going in the public court will do. Okay, next slide. So as far as the procedures are concerned, the procedures are largely contained in Rule of Court 2.830 and following. And I do suggest that you review those from time to time. When I look at them from time to time, I'm sometimes reminded of things that I might have forgotten about. So it's a useful thing to do. But generally, the appointment starts with a stipulation and order that is a formal pleading that is signed by the parties and by their counsel. And then it is also signed by the proposed private judge. And then it is sent to the court for approval and filing by either the presiding judge of the court or the supervising judge of family law or whoever is the designated judge for that particular purpose in any given county. The procedures and the forms do vary a little bit from county to county. Generally, in my cases, we use a template form that I've developed. It's similar, I'm sure, to the ones that you've seen from countless other private judges. If you've used private judges, there are some counties, not many that I'm aware of, but there are some counties that actually have a county local form, either mandatory or optional, for the stipulation and appointment of a privately compensated temporary judge. Those can often be really helpful. Even if your county doesn't use one, you can use one from another county and adapt that if you like the idea. They're generally pretty useful and pretty well written. It is interesting that from county to county, the practice can change quite a bit. In the Bay Area, I won't name the particular county, but there is one county that is just much more rigid about their rules than everyone else. For example, all the other counties in which I tend to act as a private judge are perfectly happy to have the fee arrangement between the parties and the private judge in the order of appointment. There's one county that says, no, 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 we don't like it there. That's a private matter between you and the attorneys. You have to have an agreement, but don't tell us about it. It's not going to be part of our court order appointing you. So you just have to learn some of those unique aspects that are different from court to court and sometimes adjust your stipulation order accordingly. The private judge who's being appointed has to sign a consent to serve and an oath of office. That is usually made part of the stipulation and order for appointment, though it can be a standalone document. And I have seen some situations where a private judge who is appointed regularly in front of a court signs one oath of office that remains on file with the court to be used in all of their cases, and they just have to sign a consent form for each case that comes up that references the fact that their oath is already on file. Some counties allow that, some counties don't allow that. You just have to know the local practice in regard to that. As we may have time to talk about a little bit, temporary judges are to a large degree bound by the canons that all judges are duty bound to adhere to. And of course, private judges who are acting as a temporary judge of the Superior Court are bound by all of the rules of court, including in particular the prohibition on ex parte communications. That's one that I do see some attorneys try and fudge that a little bit. They think, oh, this is such a pleasantly informal proceeding. I can just send an email to the judge to tell them what's on my mind. If you're going to do that, be sure that the other side is copied on that. And of course, don't try and have a private phone call with the judge or a private Zoom meeting with the judge that doesn't involve the other side. A big requirement at around this time is the private judge is required to make disclosures with regard to potential conflicts of interest. And the disclosures are described in pretty good detail in Rule 2.831 and also in some of the canons in Canon 6, which is the canon that does apply to temporary judges. Basically, when I'm acting as a private judge, I have to disclose to both sides other cases, including both private judging cases and mediation cases that I've handled with these parties or these attorneys or these law firms in the recent past, to give them an opportunity to see if they believe there should be a disqualification. I think it's the rules say that the disclosures have to be made not later than 5 days after designation of the private judge, the temporary judge. I think it's best practice for the private judge to make their disclosures as early in the process as possible. I will sometimes even give an informal pre-disclosure before the attorneys decide whether they want to use me or not. In particular, if I think there may be some kind of disqualification or something that might be of concern to the attorneys. And that can include, by the way, not just cases that I've handled, but it also can include personal disclosures. Obviously, if I have a financial or family relationship with somebody involved in the case, I can't take the case on at all. But it may be that this is somebody with whom I play poker on a regular basis, or I stayed at their vacation home for a weekend a few years ago or something like that. Those are personal disclosures that typically I would make because those might be of concern to attorneys. Then around the time of my appointment, my retainer is going to be paid. I think we all as private judges have somewhat different rules and procedures and amounts involved there. Mine is I have what I would call a standard hourly rate that I pretty much charge in all of my cases, but the amount of the retainer may vary given the complexity of the case. I have sort of a default number of hours that I charge on most cases, but if you've got a simple one-issue case, I might charge less than that if I think the case is going to be resolved more quickly. Alternatively, if you've got what looks like a very seriously contested case with a lot of issues, I may ask for a little larger than my usual retainer, and that typically is an evergreen retainer as it begins to get low. The wonderful staff at ADR Services will remind you and your clients that it's time to pony up a little more retainer to stay on top of things. Another thing that I do early on is that I generally ask the attorneys to send me copies of all relevant pleadings so that I can create a shadow file. In the old days, I would print all of them out and I'd actually create a booklet where I would essentially have a duplicate of anything that was in the public court file that seemed to be of importance or significance to my task. Now that is more likely to be an electronic file that I maintain, though I guess I've been around long enough that sometimes having paper to shuffle does feel a little more comfortable, but I can work both ways on that. And ADR Services has a magnificent private case management system that they developed called AMS, and you can upload all of your pleadings, and the ADR Services staff will upload any relevant pleadings that come to their attention, so that there is within the ADR Services website accessible to you as attorneys and to me as the neutral a pretty complete file of documents. So that's a really useful way of doing that. Although you are in private judging, there are some things that take place in the public court. Original pleadings are to be filed in the public court. The case is still a public court case, even though I may be your private compensated temporary judge. So you got to file your original papers with the court. You have to pay any filing fees that are owed to the court. Sorry about that, even though Judge Lopez-Giss or Judge Woolard, when they're sitting in the courthouse, they aren't going to be the ones who are going to be reviewing your papers, but the clerk's office still wants the fee. So unfortunately, that's still got to be paid, even though I'm going to be the one conducting the hearing or some other private judge will be. And then copies are sent to me, and copies are hopefully uploaded into the AMS case management system so that I have access to the documents, even though the original is down at the court file. And one thing that I do, and it's more my personal practice, though I have seen other judges do it, frequently, as I suggested earlier, before we get to trial, I will conduct a mediated settlement conference. And it looks very much like a mediation does, except that I am your trial judge, and I'm the one who's going to be giving input to the attorneys and the parties at this mediated settlement conference. When I do that, I have the parties and counsel sign a stipulation and waiver form that says they understand that even though I'm going to be having some ex parte communications during the course of the mediation, and even though I'm going to be hearing probably a ton of inadmissible evidence, nevertheless, I'm still the judge, and they can't use the fact that I conducted a mediated settlement conference as the basis for disqualifying me. Okay, next slide. This is my last slide, by the way. Disclosures are a really, really hot issue. I have talked a fair bit about disclosures already. As I say, they need to be made not later than 5 days after designation of the private judge. The disclosures do have to comply with Canon 6 of the Code of Judicial Ethics, including, I think most importantly, not just the cases that you've been on, but any information the parties or the attorneys might consider relevant to the issue of disqualification. So it's a pretty broad disclosure requirement there, and that includes known personal or professional relationships with a party, attorney, or law firm in the proceeding. Now, the attorneys that I work with regularly, they kind of know when I've worked with them. They may have some idea that I've worked with the other attorneys as well, and they've already decided that I'm the one that they want to use. But in particular, if this is the first time you've used a particular private judge, these disclosures can be extremely important, and obviously you need to go over them carefully with your client to make sure your client is aware of anything that might be of concern to them. Last thing I want to say is that the Angelina Jolie case, Jolie versus Superior Court, and we've got the citation, though you probably all know it by heart. All of us private judges certainly know it by heart. That is really kind of the hot issue in the world of disclosures. And it's complex and it has exceptions and such, but the basic rule there is not only do we have a duty to disclose all of those things that I've already described at the beginning of the case, but we have a continuing duty to update those disclosures anytime we accept a new case for either mediation or judging, is the way that I read it, that involves either the same parties or the same law firms or the same attorneys. So you will get from me and from all private judges who work with ADR Services, you will get from time to time a supplemental disclosure saying, oh, Commissioner Oleon just agreed to take on a mediation case with the attorney for the petitioner in this case, or Commissioner Oleon just agreed to take on a private judging case involving the law firm of the respondent in this case. Frankly, I think usually that's not going to cause you any particular problems, but that disclosure is there because it might. And I think we realize that that is your right based upon what the Court of Appeal has said. And so you will get updated disclosures from us. And of course, updated disclosures also if a new attorney comes into the case. So that was a lot to cover, and there's more to be said, but I think I'm done. Thank you for your attention. And I think now you're going to hear about some other alternatives to private judging.
Yes, thank you, Commissioner Oleon, for that very in-depth description of the process of temporary judges and private judging. Very, very detailed. Thank you. Next up, we have Judge Charlotte Woolard, who is going to be speaking about options with arbitration in family law disputes. Judge Woolard.
Thank you, Katie. And I'm very pleased that Katie got my introduction right. I was with San Francisco Superior Court, did 9 years of family law there, and I've been with ADR Services for 7+ years, mostly doing family law. And I'm here to talk about this kind of unusual animal in family law called arbitration. And first of all, I'd like to second and echo everything that Commissioner Oleon and Judge Lopez-Giss said. Some very good practice pointers there. But arbitration, why and why not? Next slide, please. So the benefits of family law arbitration, many of these benefits track what Commissioner Oleon was talking about in terms of temporary judges. The parties can select their own arbitrator. They can choose someone who has a particular expertise in the family law issue that you need settled. Property division is the one that quickly comes to mind. You can divide up art, antiques, collectibles. The parties and the experts provide evidence of value. And it's nice to have an arbitrator, though, that has some experience, common sense, and perhaps even a track record on the particular issue that you are trying to resolve. The proceedings are faster than going to public court. You can choose your arbitration date and schedule as much time as you need, hear it in one session or successive days instead of half day 1 week, half day a couple weeks later, etc. Family law matters submitted to arbitration usually receive a quick hearing and result, so the costs of the decision-making process are significantly reduced. It's less formal. Arbitration permits both parties greater control over the process. Both parties agree to limited rights of review and rights of appeal. In most cases, when they enter into arbitration, those rights can be expanded, as I will discuss later. Arbitrations can be done in a conference room or on Zoom in an informal setting with relaxed rules of evidence and procedures. And when you just want the personal property divided and be done, arbitration is often a very good way to go. The fourth, though, that I think really is the most significant is privacy. The arbitrators do send out disclosures about prior and current work with the parties, attorneys, and law firms. But unlike everything that happens in court being a public record, unless you are able to get portions of it sealed, and I know when I was on the bench, that was becoming more and more disfavored to seal portions of your public record, the arbitration allows the parties to resolve their disputes in a private setting in a fashion that they determine to be fair and efficient. And other than the arbitration award itself, which is submitted for confirmation to the court, none of the documents submitted in the arbitration become part of a public record. Moreover, arbitration proceedings cannot be attended by the public, and the arbitrator controls who participates in the arbitration proceeding. Next slide, please. So we have various options available, and I'm going to quickly go through them. Next slide. The Family Code does have an arbitration statute, which largely tracks the rules for small civil cases and arbitrating those. It's called Family Code Section 2554, Judicial Arbitration, though technically it's neither judicial and it's not purely arbitration. But we see a number of these come from a local county here in the San Francisco Bay Area. The judges there would make good use of this tool to resolve those pots and pans issues. I would usually see self-represented parties spend a lot of time as an arbitrator just listening to how everything is so unfair and why does the other party get to have the wedding china. One big issue in a case was who got the marital king-size bed, and including the linens, blankets, bedspread, and cushions. Why would any party want it? But these people are hurting and they need resolution. So this is a very good tool. Let's talk about the provisions of 2554. The parties do not agree in writing to a voluntary division of the community estate of the parties. The issue of the character, the value, and the division of the community estate may be submitted by the court to judicial arbitration for resolution. It's limited to cases in which the total value of the community and quasi-community property in controversy, in the opinion of the court, does not exceed $50,000. And obviously, having a small case like this go to arbitration, there's a cost savings involved. Sometimes it would cost more to litigate it in court than the value of the property itself. So the court determines that it's $50,000 or less. The decision of the court as to the value is not appealable. And the court may submit the matter to arbitration at any time it believes the parties are unable to agree upon a division of the property, and judicial arbitration awards are final unless a request for a de novo trial or a request for dismissal in the form required by the Judicial Council is filed within 60 days after the date the arbitrator files the award with the court, and that tracks the Code of Civil Procedure. Any party may elect to have a de novo trial, both as to the law and the facts, and such trial shall be calendared insofar as possible, so that the trial shall be given the same place on the active list as it had prior to arbitration, or shall receive civil priority on the next setting calendar. So again, that tracks the small case arbitration provisions found in the Code of Civil Procedure. Next slide, please. So let's take a look at contractual arbitration. Marital property division. In domestic relations disputes, spouses can agree to arbitrate the value and division of their marital property. And indeed, out-of-court resolution of these issues is encouraged. I know very few judges on the bench sitting in court that want to go through these types of issues in a hearing or a trial. You take a look at the Marriage of Cream case, and in that case, Justice King included an appendix at the end of the decision that talks about the methods of division of community property other than by judicial decision. And it's a good case to keep handy, just, to take a look at all the different ways that you can divide the personal property. In terms of child custody and child support, agreements to submit future child support issues to binding arbitration are void as against public policy because they deprive the court of jurisdiction to modify child support. Take a look at the Bereznik and Heminger case. Also, agreements to submit child custody issues to binding arbitration, preempting court authority to intervene, may be unenforceable. Take a look at Gedarzarad. And parties cannot, by agreement, oust the court of child custody jurisdiction. In Armstrong versus Armstrong, it's noted that parents' statutory support obligation is unaffected by any agreement between them, and child support orders are modifiable despite parents' agreement to the contrary. So the court in child custody and child support cases really do want to retain that control. Next slide, please. But there are some workaround options for child custody and support. So long as the arbitrator is bound to apply governing law, such as the mandatory statewide uniform child support guideline, and the arbitration agreement preserves normal rights of appellate review and does not foreclose judicial intervention by way of subsequent modification proceedings, there is arguably no sound reason why child custody and support disputes should not be arbitrable. The only real public policy concern is the courts not be foreclosed from exercising their role as parents patriae to protect the rights of the minor children. So the courts and society determine that the courts need to retain that power to protect the children. Next slide, please. In a case dealing with the enforceability of settlements reached at arbitration, the California Supreme Court seems to have implicitly approved the practice of allowing the parties by stipulation to submit disputed child custody and child support issues, along with other contested domestic relation matters, to binding arbitration, subject to the normal rights of appellate review. In the Assemi case, by the parties' stipulation, and this was a marital dissolution proceeding, the trial court referred spousal support, child support, and other contested issues to binding arbitration before a retired judge appointed as an arbitrator. Although the appointment order was somewhat ambiguous, with the proceedings to be transcribed and governed by the rules of evidence and court procedures applicable to Superior Court trials, and subject to either party's right to appeal the arbitrator's decision. So, as I said, there was some ambiguity about whether the arbitrator was actually acting as a temporary judge as authorized by the California Constitution. But in the Assemi case, there was no record that the temporary judge took an oath of office as required by the Constitution. And without that, he could not be acting as a temporary judge, but instead as an arbitrator. So the Supreme Court concluded that the arbitrator was empowered to act in a quasi-judicial capacity as arbiter of the controverted issues. So I'm not advocating for arbitration, but it's an interesting idea to consider arbitration with all the workaround options that we've discussed if counsel and the parties are in agreement to arbitrate the matter due to privacy concerns. So I think that's something that just at least should be considered. Appellate review of arbitration awards on the merits is allowed by agreement. We have the Cable Connection versus DirecTV case, which is on the slide, that a Supreme Court case disapproving conflicting Court of Appeal decisions. So you can stipulate to have the arbitration award be subject to the judicial review by the Court of Appeal on its merits, such as for errors of law, which typically are not possible under your standard arbitration. Next slide, please. So, can the Federal Arbitration Act, the FAA, ever apply to family law arbitrations? And I think it's rarely, because family law cases do not typically give rise to disputes involving transactions in commerce. The FAA will not usually apply to these arbitrations. However, the problem of preemption could arise in a family law case if it has interstate aspects, for example, where conflicts over marital property or spousal support cross state lines. In those cases, agreements to arbitrate might fall within the parameters of the FAA, and as such, the FAA may preempt a state arbitration statute imposing special requirements inconsistent with the FAA. Next slide, please. So we also have the Uniform Family Law Arbitration Act, which was developed to try to standardize the rules of family law arbitration. The American Bar Association approved the act, and it's been recommended for enactment in all states, but so far only 4 of them, Arizona, Hawaii, North Dakota, and Montana, have done so. And this PowerPoint does contain a link to the act if you wish to take a look at it. So the types of family law disputes that this act potentially covers the arbitration of any contested issue arising under the enacting state's family law. Typical issues would be property division, allocation of debt, spousal support, parenting time, child support, interpretation of marital agreements, and attorney fees. The act excludes certain status determinations, such as the termination of parental rights or the granting of an adoption, from the arbitrator's authority. And the act does not cover agreements to arbitrate according to the tenets of a particular religion or before a religious tribunal. And I'm not spending a lot of time talking about the act, as only 4 states have adopted it so far. It's sufficient to be aware that it is lurking out there So be warned. So that's enough about arbitration. Thank you very much for listening.
Thank you, Judge Woolard. That was a lot of really great information about something that I think a lot of our clients aren't very familiar with. Arbitration has been quite unusual in our experience in family law disputes, so it's good to see how it can be used and utilized. Next up, we have Rich Roggia speaking on references. Rich?
Good afternoon, and thank you. My name is Rich Roggia. I started practicing as a private practitioner in 1972, emphasizing primarily trial work and family law. Around 2017, 2018, I stopped litigating and representing clients in court. I've been working with ADR as a temporary judge, a mediator, and at times a referee. Many of the positive points and that Commissioner Oleon had talked about with reference to flexibility in scheduling, with reference to the ability to pick the trier of fact, whom you know to be an individual of some experience in the family law areas, as well as scheduling and the location of where you might want to have your particular hearing. Those would likewise adhere to the appointment of a referee. When we're talking about the appointment of a referee, what I would like to emphasize is that as a family law practitioner, how would the appointment of a referee under either 638, which is a consensual appointment, or 639, which is an appointment either on the court's on motion or on the in the motion of one of the parties over objection, how is that going to benefit a family law client? Why don't we go to our next slide? So a consensual appointment deals primarily with the ability for the parties to pick someone to hear and determine all of the issues in an action or proceeding, whether fact or law, or to ascertain a fact necessary to enable the court to determine the action or proceeding. Next slide, please. So I think that's very important because you may have a case, and we've all had them, where data separation is important. It's certainly going to take, if you've ever tried a data separation case, it's going to take certainly more than a half an hour. It's going to take then months to get that on calendar through the normal system. And during that period of time, you really can't engage in any normal course of discovery. You're not going to be able to hire your experts in forensics with reference to the division of your retirement benefits. Because that depends on the data separation. You really don't know about the marital standard of living, do you? Because you're going to have to determine that data separation. So that is a particular fact, which if found to be one way or the other, the court is then going to have the ability, the trial court, the trier of fact is going to have the ability, and the attorney is going to have the ability to schedule their discovery along the same lines. Validity of marriage, the validity of the marriage is also another factor. Which I've had occasion to rely upon a referee under a consensual referee under 638, because there may be punitive spouse issues and whether or not there is a valid grounds for a nullity. Alternate valuation date, I think, is extremely important in many cases now under 2552B of the Family Code. If you have a situation where perhaps one of the parties ran the business into the ground subsequent to data separation, or certainly if you have a separate property claim of a business that started prior to the data separation, and you're looking at which particular method of apportionment you're going to use under Pereira Van Camp, you can have instead of waiting months and months to get an evaluation or to task your forensics with making that particular evaluation by appointment with a referee under 638, you can probably get that done within a month or within certainly 45 days. I think the issue of the validity of a premarital agreement or marital settlement agreement is pivotal in many cases. I mean, how are you going to really talk about what's the community estate if what you have is the validity of a premarital agreement, which is pivotal? So those are types of issues under 638 A and B that the parties can stipulate. Now, next slide, please. If it's a reference under 638, the referee's decision, statement of decision, is the same as if it was issued by the court. It may be accepted to or reviewed in a like manner. In all other cases, that would be a non-consensual referral under 639. The referee's statement of decision, or statement of intended decision, if you will, is advisory only. And we'll talk about objections thereto and how that would be done. Next slide, please. So I'd like to talk about the area of discovery. I think most of us are familiar with utilizing referees in discovery, and I would encourage the parties to agree to a 638 consensual referral as to a discovery special master or discovery referee for all discovery issues in a particular case. I've had many cases, I'm sure you have had, where there are a multiplicity of discovery issues, and those issues will continue to arise, and to have to go back to court each time with a separate statement, and which is, we've all known the time and expense it takes to prepare a motion to compel or a motion to quash or a motion for a protective order. To be able to have access to a discovery referee for all purposes, who can call balls and strikes at a deposition, perhaps, with a particularly litigious client or opposing counsel, saves a lot of time. What I've seen recently, the area where a 638 or even a 639 over objection referee has been very helpful. The area of medical records. Maybe it is a spouse support case where there is an allegation that one of the parties is infirm and is unable to work, and your vocational expert says, "Well, I don't have any information otherwise. I need to know whether or not the wife or husband is in fact physically impaired." And then you'll look at those medical records. Those medical records under HIPAA are protected. They have rights of privacy. There are all kinds of other things in those medical records that are subject to certainly more stringent review and have nothing to do with the case. So what we have are discovery referees who review those records in camera and make appropriate redactions and decisions. Psychological therapist records, likewise. There may be a privilege to have none of those records revealed. On the other hand, the question is whether or not one party has posited that and made that an issue. And if so, how and in what fashion are those records to be evaluated? The discovery referee would then be appointed to do that. Employment records, I recently had a case where there was a move away, and the question was this move away in good faith or not? And there was a request for all employment records, including personnel files. So, and in California, employment records are protected under rights of privacy in the California Constitution. So you would have your discovery referee then review those in camera and redact them. The same with third-party financial records. To the extent that there are third-party financial records, those third parties certainly have a right to privacy. They have a right to have their records reviewed in private, in camera, and to have a balancing test undertaken in terms of the individual litigant's legitimate need to know and the court's legitimate obligation to dispense justice even-handedly with that party's particular right to privacy. So I would recommend and I would encourage in a fairly complex case, or in a case with a particularly arcane set of discovery issues, the appointment of a discovery referee under 638 consensually for all purposes. Next slide, please. 639 deals with an appointment over objection, and primarily you will see that where both parties are litigating very strongly in court. And it's now in front of the judge, and there are literally stacks and hundreds of pages of separate statements and objections, and 85 separate requests to produce, and 83 separate objections and requests for protective orders and motions to quash. I've seen in seven times out of 10 that judge is going to say, look, take this to a discovery referee. Either you folks agree or I'm going to appoint one right now. There's a whole process for how that is done. We did not get into it. I've included that with the materials. But I would like to emphasize in particular 639A5, where the court says in that particular instance, the court has the ability over objection to appoint a discovery referee and to hear and determine all discovery motions or disputes related to discovery, and then to make a recommendation. Next slide, please. That simply deals with how and in what fashion the court would appoint those referees over objection. Next slide, please. If it is a non-consensual appointment and the court has appointed a discovery referee or any other referee, that report must be rendered within 20 days. If it is a report, if it is a referral under 638, the recommendation or the statement of decision can be done in accordance with however the parties desire. So there's some more flexibility with a 638 appointment. If it's a 639 appointment, that decision has to be rendered within 20 days of submittal. Next slide, please. Under 639, if the referee's appointment is objected to, it must be objected to within 20 days. Either party then has 10 days in which to object to the recommendation. The recommendation, again, is submitted within 20 days. Any objections within 10 days, any responses to those objections within 10 days, and then the court will either adopt the referee's recommendation in whole or in part, or deny the same. Under 638, there is no objection as such. The referee's decision stands as a decision of the court. It may be reviewed or accepted to in the similar manner. Next slide, please. I think it's important to note that if it's a non-consensual appointment and the court is appointing a referee, the court cannot simply say, I'm going to appoint you to decide any and all issues. And that was the Ruisi versus Thoreau case, with which I think we are all familiar, especially those of us that have done a lot of family law custody work. But at any rate, so a non-consensual reference under 639 must be limited as to a specific factual question. You can't simply say, boy, this case is really difficult. I'm tired of it. I'm going to appoint a referee and they're going to decide the whole matter. So that pretty much takes care of the referee referrals. I think it has a lot of the same benefits as the appointment of a private judge. I think the process may be a little more expedited. Certainly, you're going to get a decision at a minimum within 20 days, as opposed to perhaps having to wait 90 days for a private judge's decision. But a lot of it depends upon the particular needs of your case and your particular client. So thank you very much.
Thank you, Rich, for that very quick and in-depth coverage of 638, 639, all kinds of referee appointments. We do have a few minutes remaining here, about 10 minutes left. So I would like to invite our panelists to give us any closing thoughts or any considerations you might have, some thoughts about the best approaches or how to decide what kind of type of ADR program to use for a particular case.
There was one question in the Q&A that I thought was actually a very cogent one. And since I don't think everyone can read it, I will restate it. The question was, can the use of a private judge get around requirements of local rules that a copy of a marital settlement agreement be attached to the proposed judgment, or that an income and expense declaration be submitted to the court, and per the family code, that the court retains jurisdiction to order and or modify spousal and child support? The answer is frankly a very flat no. As I suggested, we are appointed not as private judges pursuant to whatever rules the parties want to adopt, but we are being appointed as a temporary judge of the Superior Court, and we are required to follow all of the rules, including the local rules that judges of the Superior Court, judicial officers of the Superior Court are required to follow. So if your court has a local rule about MSAs must in all cases be attached to the proposed judgment, if we are approving a judgment, we have to follow that rule. If there's a rule of court or a statute that says an income and expense declaration has to be submitted to the court, that rule has to be followed. And in particular, you cannot stipulate to non-modifiable child support just because you're using a private judge. We are required to adhere to the same rules as the judges in the public court. There was an example that I'm aware of a private judge in the Bay Area who frequently was engaged to approve judgments. And I think probably this particular person was chosen because they maybe weren't quite as detailed in the how closely they looked at all of the specifics of the judgments they were being asked to approve. And I know of a particular court that actually no longer will appoint that particular individual as a private judge to approve judgments because they felt that they were not diligently following the local rules with regard to judgments. So yes, we are required to follow the same rules, and you cannot get around those rules by using a private judge.
Mm-hmm. Thank you, Commissioner Oleon. To pitch my final question to the rest of you, how would you assess a case to determine what's the best version of ADR to use? If you mediate a case, if you get a judge pro tem, what are some considerations that you think attorneys should take into account aside from what the options are available? What about a case might lead them one way or another?
I'd like to at least answer that for Los Angeles. I can't speak to Northern California. Our courts are extremely backloaded, and it's taking a long time to get hearings. And you know, I'm of the opinion, since I settled most of the cases I ever had in 15 years, that mediation is always a good first step. I really believe that. However, there are people who will just not agree. And I think that in those cases, after mediation and the issues are honed, that going to a private judge and getting that matter resolved early actually saves the parties an enormous amount of cost emotionally as well as financially. And you can get on calendar anywhere, at least with ADR, much sooner than you can in the Los Angeles Superior Court. That's not a criticism of the court. It's just a fact because of COVID. It's a fact because there's been a big turnover and it's just impossible. And I, again, cannot speak to Northern California, but I really think that many issues can be resolved earlier and you get answers and you get closure. So on those issues, I think private judging. On huge discovery issues, I think earlier that you get a discovery referee in place, the easier it is.
Mm-hmm.
Yeah, I agree with Judge Lopez-Giss. One of the things I really like about working with ADR Services is that I have a greater ability to meet with counsel, conference with counsel, and even meet the parties. I didn't really have time to do that when I was on the bench. And we can get an awful lot done just by talking and exchanging ideas and working with counsel and the parties to reach an agreement. So, you know, I think that to me is the big difference.
Yes, I would like to emphasize getting there earlier in the case as possible, what Judge Lopez-Giss had indicated, because what I used to see, luckily I'm not seeing it as much anymore, but I would see cases referred to me as a limited purpose settlement judge that were on the trial calendar and then sent to the master settlement conference calendar. The case had been going on 4 or 5 years, and I'm looking at it. and trying to settle the case. And I'm saying, well, there's $200,000 or $300,000 in attorney's fees and experts fees that had already been incurred. Had this case had the attorneys and our clients made the decision to do this early on, because I'll tell them if they come to me early on and I say, this is my recommendation, this is what you're looking at in terms of a mediation. And you don't like what I'm hearing, well, you're going to hear the same thing 3 years from now at a master settlement conference, except the judge there will not have had 2 or 3 days to review the documents. And you're going to hear the same opportunity, the same alternatives, except it would have cost you $200,000 or $300,000 more. So the earlier that you can get in to get that independent assessment, to try to mediate it, because all of that money that is going to be spent in litigation down the road is just going to be spent again, because you're not going to get to trial, as you know, before that trial judge says, have you been to a master settlement conference?
I would like to address disclosure. There are many attorneys who think they shouldn't go to mediation until after discovery. Many people litigants do not understand under 721 of the Family Code. They have to turn everything over without a subpoena, without a deposition, without a request. And I think if you have an independent neutral telling the parties that this is what they're going to have to do and what sanctions they will be looking at if they don't, you actually have an assistant in getting the information sooner.
Judge Lopez-Giss, in your section, you spoke a little bit about some of the issues that you'd like parties to meet and confer about before they come to mediation, such as how much money have we spent, what's really in contest here, where's the other party. I'd welcome any of the panelists to give feedback on any other issues you think that attorneys should try to address before they come to mediation to be set up for success. That's Commissioner Oleon, we have you on mute.
No, I know. This time I held off until I unmuted myself. Eventually, I learned lessons like that. It's a somewhat indirect answer, but I think it's pertinent to what you just raised, Katie, and that is when I'm acting as a mediator, I feel very, very strongly that I would like to have thorough mediation briefs from both sides, and I would like those mediation briefs to be exchanged between the sides, because that enables us to get up and running right off the bat and spend much less time on preliminaries during the mediation session that we're going to be holding together. And it also educates me as to which items really are disputed issues and gives me an idea of the nature of the dispute, and which items really are not in dispute, things that we can not have to spend as much time or energy on. So, in terms of being advised by the parties as to what matters and what they think is important and what they would like to see focused on, I think the mediation brief can be a wonderful, wonderful tool for doing that.
I would just like to indicate that when I do mediations, I use those briefs and have pre-mediation phone calls with both counsel, usually together and then independently, because it helps crystallize what we're going to talk about. I tell counsel there's no surprises with me. They're going to know what I'm going to say. I'm not going to ambush them or their clients. And it gives counsel an opportunity to tell me and share with me some issues they may be having issues with their clients, so that I'm apprised of it. And like I said, I will do that privately so that I am prepared to help you. And I think that that is something that, if done earlier, as Ms. Rich Roggia said, when you do it earlier, you really have a whole lot more control as counsel in the case.
Great, thank you all. We are here at the end of our program. Thank you all so very much for participating in this, and thank you for all of our attendees for coming out today.